It was almost depressing. I think I need a therapist, Pete. Welcome to the Three Wise Men of Divorce, Money, Psych, and Law podcast. Sit down with the California divorce experts, financial divorce consultant Mark Hill, marriage and family therapist Pete Russos, and attorney Shawn Weber for a frank and casual conversation about divorce, separation, co-parenting, and the difficult decisions real people like you face during these tough times. We know that if you are looking at divorce or separation, it can be scary and overwhelming. With combined experience of over 60 years of divorce and conflict management, we are here for you and look forward to helping by sharing our unique ideas, thoughts, and perspectives on divorce, separation, and co-parenting.
So guys, I got a question for you, something I've been curious about. And, I think this would be interesting for me and I think interesting for an audience. But what are the common myths and misconceptions about the family law system that people hold?
The family law system. Just to be clear, I remember my professional responsibility professor at law school always saying that litigation is like a meat grinder. You go in a pig and you come out a sausage. Like, imagine that image, right? But I think people don't realize how destructive litigation can be. And this is not meant to poo-poo litigation. It's a tool that is meant for certain cases. That's just all you can do, and it's appropriate. And the professionals that work in the litigation system are doing good work, I think, for the most part. But people do have, I think you're correct, Pete. People have misconceptions about what they can even expect there.
Well, I'm curious, when clients are coming in to meet the two of you for the first time in your practice as prospective clients, what are the examples of the myths and misconceptions that you literally have to clarify or disabuse them of? What do you have to explain about how the system works?
Well, how about ascribing fault in a no-fault system?
Yeah.
So somebody comes in saying he or she was awful in the marriage, did terrible things, and therefore I should get what I want.
They want their pound of flesh?
They want to be paid for the harm they've been caused on top of what the normal court process would do.
Yeah, you caused this, so therefore I should receive this, or you should have to pay for everything.
Mm-hmm.
And the reality is, in the system, so that's the myth. What's the reality?
Nobody cares whose fault it is in the system. And it's a court of equity. And even if it was somebody's fault, the court isn't going to determine that. The court is going to just divide things according to equity. Mm-hmm. If you're in a community property state like we are here in California, you're just dividing the community property in half. Mm-hmm. It doesn't matter if you earned it during the marriage. It doesn't matter if you're the bad guy or the good guy. We're dividing in half. And a lot of people don't realize that.
Yep.
And so then there's this mistake that happens where people are thinking, well, if I can just get my story out there, the judge will see it my way and give me what I want. And no. The judge is going to apply the law, even if the law is stupid, even if the judge doesn't agree with the law.
I've been told by judges, all we see is two warring parties, and we don't know really what the truth is beyond what has been presented in a very short format.
Well, and then related to that is what I call the myth of justice. Mm-hmm. You have that concept of the goddess of justice, that it's always on a seal at the courtroom, or there's a statue of a lady there holding the scales of justice, and she's blindfolded, she's blind, and she's going to apply the law blindly. That doesn't really happen. There's no such thing as justice or fairness at court. The court strives for fairness and justice, but you know, we've always said this before, fair is the F word. Um, it's like, or as Mark says, it's like beauty. It's in the eye of the beholder. What you believe is a fair outcome may not be what the other person believes is a fair outcome. And the court's not able to just make something feel fair to you. All the court can do is apply the law.
Mhm. Well, in within that construct of applying the law, how much room, if you will, is there for the biases that as human beings we all have, that a judge has, or that attorneys have? You know, how do you think of bias in the context of the legal process?
Well, I think number one, there's an aspiration to be non-biased when you're a judicial officer. It's in the judicial canons that you shouldn't carry a bias. But the reality is all these judges, they're human beings. They'll be the first to tell you we are human. Um, I think I was telling you guys before we started recording, I went to a judicial temperament training one time, and there was a commissioner there that I knew pretty well, and he was distraught that he took a test. There was like an online test we were all supposed to take to kind of show us what our unconscious biases were, and he was distraught that he had a bias in favor of white European men. And then the person that was facilitating the training was a black female judge. And she had taken the same test, and she reported to all of us, yeah, it kind of surprised me. I have a bias in favor of white European men. So you never know what kind of bias your judge is going to bring. And judges are receiving training to control their unconscious biases, but sometimes some are better at it than others. And so many of the issues in family law, like custody, parenting, I mean, there are laws and case law that are supposed to kind of guide the judge's decision. But the reality is everybody has a bias, and they're going to be influenced by their bias. Sometimes they don't even know they have it. And so there's some risk there that you'll go and you won't even know what bias this judge has. And it can influence you. It can influence your decision in a way that's maybe negative for you and maybe come out as a way that you feel is not fair or just.
And I've heard, Shawn, that basically in family law, it's a little different than other areas of the law where there are very few appeals that get upheld. So there are very few appeals, basically. So it's what your judge decides is what you're going to get. And the reason for that is people walk out of divorce court, and it's not unusual to see both sides really upset and dissatisfied. And, given the opportunity, I think many people would appeal. But I've heard attorneys tell clients, no, you don't want to appeal this. This is, even though I think we had a really good case, very little gets overturned on appeal in family law.
Yeah, I mean, there are certain rules that have to be applied in a certain way, and judges do a good job of just kind of covering themselves enough to show that they followed the law. But then those areas where they have discretion, there's not really much you can do.
What are the areas where judges have discretion?
I think a big one is parenting and determining what's the best interest of the child. There are certain burdens of proof that can shift depending on what's going on. Like if you have a person that's an alcoholic, or you have a person that's abusive like an abusive person that's been violent with domestic violence, there are certain procedural evidentiary questions that come up as a result of those actions, and burdens of proof shift around. But for the most part, what is in the best interest of the child, that is very subjective. And the judge is going to try their best to figure out, well, what is in the best interest of this child? But at the end of the day, it's really up to the judge what's in the best interest of the child. And as long as a reasonable person could make a cogent argument in favor of what the judge is saying, then that will survive on appeal. It's only when a judge doesn't follow one of the burdens or doesn't make a required finding that there could be, or there's just a blatant abuse of discretion, which is very hard to prove. Can a best interest of the child finding be overturned? It's very difficult. Another area is in the area of spousal support. the amount of spousal support. Especially in California, it's a very wide range of discretion that the judge has to determine. They're not allowed to use a computer system to just tell them what the number should be. They have to just kind of make a judgment call based on the factors. And there's a list of factors a mile long in the family code about what they're supposed to consider. They have to consider the factors. If they don't consider the factors, it can be overturned.
Shawn, can I just jump in and ask you? It's interesting because am I correct in my understanding that child support is much more formulaic?
Yeah, that's a guideline. That's just it's a formula.
Huh.
So there's very few circumstances where a child support order can be anything but the guideline. But with spousal support, it's not that way. And so the judge has an enormous amount of discretion. And as long as the judge is able to show that he or she considered the mandatory factors that, it's a list of factors like, did someone give up career so that the other person could have a career? Did someone perform more domestic duties than the other person? Things like that. Well, none of which have anything to do with what is the number that should be the spousal support.
Hey, guys, can I actually try to steer this a little bit? I'm just thinking about this conversation, and what I'm aware of is regular listeners to the podcast have heard us many times talk about why we are such believers and devoted to the practice of mediation, collaboration, alternative dispute forms of resolution, right? So and what we talk about is how when people go to court, they're ceding these decisions about these monumentally important things in their lives to somebody else. So, folks who listen to this know where we stand vis-a-vis litigation versus what we do. And so I'm wondering, this is a long-winded way of steering, if you will, something that's more in let's go to our wheelhouse. What are the myths and the misconceptions that people have about mediation and collaborative divorce? Because there are also, I think, a bunch of those that we've heard and that we talk about.
If I don't have a strong attorney fighting for me, I'm going to end up losing.
Yeah. Or one myth that people come in with is it's either going to be A or B. Like I call it the false binary. It's going to be either I win or he or he wins. It's a false binary, and without understanding that in mediation, what sometimes we look for is the chance for both to win or both to lose similarly.
I mean, there are some financial issues that, if litigated, the judge is required to choose A or B.
Yeah.
Whereas in alternative dispute resolution, we can be a little grayer and say, well, maybe a 40-60 split here might work for you guys. But the judge doesn't have that choice. They have to pick A or B. And that is probably not what at least one of the participants wanted.
Well, Go ahead, Pete.
I think, and regular listeners have heard the two of you say, I think, a number of our discussions, and it just is so striking to me, one, because of the realism of it, but that a really successful, healthy mediation often means that both parties are a bit disappointed.
Yeah. I kind of joke with my clients, if you're both disappointed at the end of the day, then I've done my job. But what it means is they've compromised. They're in the popular culture today, especially with the politics out there, there's this notion that a compromise is some kind of a dirty word, like we shouldn't compromise. And we as mediators and alternative dispute resolution practitioners understand that a compromise is actually a good thing. It means you've gotten, you've managed risk. If you go to court, you like Mark said, the judge has to pick an answer. It's not like you can go in and say, well, I have this appraisal that says that the house is worth $1.5 million, and I have this other appraisal that says the house is worth 2.5. So, judge, what do you think? And the judge could split the baby in half, and pick a middle number. Judge's not allowed to do that. He has to either pick the 1.5 or the 2.5.
A myth that I have encountered is people thinking that if they go into a mediation process, they actually can be more secretive.
Yes. Yeah. It doesn't work very well that way.
Mm-hmm.
Or the fear corollary to that, the fear that my spouse is going to be more secretive. And so therefore I'm at risk if I go into mediation. And what we found is it's just the opposite, that people are more likely to share information in a mediation context than they are in a courtroom situation. And the reason for that is simple. I mean, when we're in law school, we're taught when there's a discovery request that comes our way to share as little as we can legally get away with.
Mm-hmm.
Whereas in mediation, because people are not just completely under the gun the whole time in this adversarial battle, people are more likely to share. And the good news is mediation can't continue unless there is sharing going on.
I think one of the most important things about the work that we do in this kind of process is helping people who are ending their marriage get to a place where both parties feel like they're sharing sacrifice fairly. And because it's mediation, they get to decide what fair is.
The two of them together. Yeah.
Yeah.
Or what's a good business decision?
Mm-hmm.
Like maybe we can't even get to agreeing what fair means. Like I mentioned, fair is kind of the F word.
Mm-hmm.
Yeah.
So then, well, what's a good business decision for you? What's going to make sense as far as this particular issue so that you can reduce the risk of what could happen to you at court and you can end this conflict?
Yeah.
And the other thing that happens when you're at court, there's different reasons why people have conflict. There's different reasons, or let me rephrase that. There's different methodologies for how people resolve their conflict. Some people resort to power. I'm going to have power over you. I'm going to, maybe I'm going to be violent. I'm going to force you to do something, or I'm going to use some kind of legal authority that I have. Or there's rights, where we're trying to figure out who's on the right side. And that we see power and rights brought forth in a litigation context. But what you don't see in a litigation context is what are the parties' interests. And what we found is with interest-based negotiation is you can actually get people more of what they want if they can agree than if you went to court. And one of my favorite examples of this is, there's a parable of two old ladies fighting over an orange. You've heard that one?
No, I don't know.
Okay, so two ladies fighting over an orange. And so then they go to the magistrate or whoever the person is that decides these things. And he comes up with a solution. The solution is we're just going to cut the orange in half. And each of them gets half an orange. They should all be happy, right? Well, no, because what really was going on is when you look at the interests of what these women had, one woman's interest was she wanted the zest from the peel, and the other one wanted the pulp. And they could have both had 100% of what they wanted if the magistrate would have stopped for a moment to figure out what their interests were. But when you go to court, it's just about applying the law. So we're just going to cut oranges in half. We're going to just apply the law no matter what the interests are. And so you can't get creative at court. I mean, it's one of the strengths of court. The judge is always going to apply the law, right? But the negative to court is that the judge must apply the law.
Yeah.
Are there myths and misconceptions, or what are the myths and misconceptions that you see vis-a-vis cost of mediation and collaborative? How people think about the costs of those processes?
Well, I mean, I don't know what you think, Mark, but I think that people, when they hear how much a mediator will bill per hour, they kind of get nervous that this is going to be just as expensive as going to court. So I might as well just hire an attorney because they may have a similar hourly rate. But what they don't realize is how much more hours are spent in court and how much those hours are completely out of control with all the experts that you hire. Whereas in mediation and collaborative, you have a lot more control over the costs. You spend a lot less time. You pick your experts together at the beginning and really control their costs instead of letting them get picked at the end when it's out of control. And so with litigation, you tend to have more of a runaway train. Whereas,
and I think, Shawn, that they don't really have a good understanding of what they're in for.
mm-hmm.
I think in mediation and in collaborative, we do a fairly good job of laying out what costs could be. And we don't know. I mean, people ask me how much this is going to cost. I use an old English expression: how long is a piece of string? The longer you pull on that ball, the longer it will be. So it's not easy to determine it. But then you get this retainer talk. Oh yeah, just give me $5,000 and we can get going on your case. Oh well, 5,000 is not bad. That's okay. I can afford that. But what that won't even do is get you through your declarations and the necessary court forms done.
Yeah, that's just your first retainer.
Exactly.
And it's going to keep going and keep going and keep going until that case is done. And you could be in six figures before you know it.
One of the things that a discussion that I have with prospective therapy clients, because I'm often asked, how long is it going to take? But I will talk about how my experience is that it almost always takes longer than clients want it to. And that it's therefore also more expensive than clients hope it will be. And I'm wondering if there's a parallel in your practices. Does mediation typically take longer than people expect it will take?
Yes, it takes longer than people expect it will take. But then what I have to teach them is that if you were to litigate this, multiply that time by 10,
Yeah.
and it'll take much longer because the wheels of justice turn slowly. It's part of why it's so expensive. You've got this relationship with this attorney who's your zealous advocate, but the wheels of justice are turning slowly. It's hard to get to a hearing. And so every minute you spend with that attorney is costing you money.
And everything that your soon to be ex-spouse's attorney sends to that attorney requires a response.
Yeah. And so
which has a cost associated with it. But I mean, people come into alternative dispute resolution with unrealistic expectations too. I mean, I always tell people it's probably going to cost you more than you want it to, take longer than you hope it would, and be more emotionally painful than you anticipated. Be aware, this is not easy. This is difficult. And I tell people, it would be unrealistic to expect the divorce to be that much easier than the marriage was, wouldn't it? And sometimes that will get people's attention. They will understand, that these, no matter what you use, which process you select, there will be challenges with it. And unrealistic expectations can be very frustrating when they're not addressed up front.
Well, it related to the money that you spend on the process too. A lot of times when I used to litigate, I'd have somebody, it's a custody case. I love my child and money is no object. I'll spend whatever I have to spend. And pretty soon they realize money is an object because it's finite. You only have so much. And there will be a point, I don't care how rich you are, where you will run out of money if money really is no object. And the other thing is spending more money isn't necessarily going to help your child more. In fact, it could actually harm your child more. Like if you get engaged in a really adversarial process where the parents are at each other's throats. I mean, we know from research that hurts kids. And also from experience, we watch it happen in real time. They always say no one hates war more than a warrior. And I think that's true. No one hates litigation more than somebody that's actually litigated and has been in the trenches and knows what it's like.
Yeah, very true. Yeah.
Yeah. And then, go ahead.
How common is it also that people will think, oh, if I could just get on the other side of the divorce, once we get done with the divorce, things will be better between us?
Oh, yeah, that happens a lot. People think that once the trial happens, it's over, the battle. But the problem is when you're in litigation and you're engaged in a process that encourages conflict, an adversarial process, you're not feeling better about the other person at the end of the day, and the conflict will continue. Whereas in mediation and collaborative practice, we tend to because it's a non-adversarial process, we're trying to find solutions. The agreements that the parties create for themselves tend to be more lasting and enduring than the ones that are imposed upon them by a judge because they created it together.
I think there's also, particularly when coaches are involved and there's an interest on the part of the parties to try to create a healthier process between them. I think that sets the stage for a healthier and more collaborative post-divorce co-parenting dynamic?
Well, I was on a call this morning on a very difficult case where there's two attorneys, there's a parenting coordinator, a mental health professional, and the conversation that these three professionals were having was these parents are destroying their kid.
Mm.
Kid's going to have a personality disorder. This kid's going to have a problem. They better be saving their money for the therapy bills. We're worried he's going to have, all kinds of problems when he gets older, including suicidal ideation and drug usage, all the worst case scenarios, right? Because we've seen the movie before.
Yeah.
And
that brings up a point. Well, it brings up a point that you raised earlier, I think, when we were chatting about this before we started recording, which is the fantasy that you go through a court trial and everything's ended, everything's complete.
Yeah, it's not ended.
Yeah.
It's not ended. You're gonna have. I mean, I used to make more money as a litigator doing post judgment motions than I ever made in the main case.
Really?
I always made more money on the post judgment. Yeah, because
Wow.
it keeps going. It keeps going. You got a relationship with this client until the kids are grown, and you can do a lot to short circuit that in non-adversarial processes. And I think related to that is the myth of this concept that if I get a really good zealous advocate, a gladiator that's going to fight my war for me, that's going to be good for me and my family. That's going to be, and really what that ends up doing is there's a lot of costs associated with hiring that person that you don't realize. And one is the absolute destruction of the relationship with the other person. And so, I'm always asking my co-parents, do you want to dance at your daughter's wedding? And we've heard those stories of people where the other person doesn't even come, neither parent comes to the wedding because they're afraid the other person's going to be there. Or it's just this uncomfortable, awful thing. Would you like to have could you imagine having a parenting relationship where you're not having to go to bed at night worried about what the other person is going to do?
I've shared this before in one of our discussions, but and this goes back probably 18 years. The case that I had when I was still doing court-ordered therapy, and had a woman that I was working with. Both parties were court-ordered into therapy, and at some point in time, I asked her, how much have you spent on your divorce process so far? And it was $500,000, and there was no light at the end of the tunnel for them. So she and her soon-to-be ex-husband, well, not so soon-to-be ex-husband, but at some point in time would-be ex-husband, hated each other, and they had hired two attorneys who hated each other.
Mm.
And it was this perfect storm, a very, very costly process in financial terms and in emotional terms, and just brutal on their children. Mm-hmm. And among other things, that case was the reason why I thought, well, I'm not doing court-ordered therapy anymore, in large part because my experience was that people who are court-ordered generally don't want to really participate, and it was useless. But it also steered me even more fully into collaborative work.
Mm. Yeah, that's interesting. I've done mediations where attorneys are involved, and sometimes the attorneys are worse than the parties. And you see these parties looking at you, please, God, help me, and then you see these attorneys just loaded for bear, ready to go after each other because they think that's what they need to do. Or maybe, like you said, they actually don't like each other. It has nothing to do with the parties. It's just their animus towards each other. And having to wrangle these attorneys to think, what are you doing to this family? I remember this couple of attorneys one time in particular where they were just arguing like I was the judge and I'm the mediator. I'm like, look, you understand that I don't have the authority to decide anything, right? So all of this effort that you're spending arguing your legal case is not helping you. Can you come up with a proposal that the other person might accept? And kind of telling them, look, you're destroying this family and you're destroying the children that are in this family. Usually that doesn't go over well, but sometimes I'll have an attorney that it shocks them into better behavior. Yeah, this myth of thinking, well, if I hire the nastiest attorney I can get, that's going to help me and my family. It'll probably end up costing you more money than you have. They'll probably end up dropping you at the end of the day because you can't afford them anymore. And so when you're most vulnerable, they'll drop you like a hot potato because you can't pay their bill. And then you'll be stuck hanging the bag, holding the bag. You know, they don't care that it's your life.
Well, and I think as you're talking about that, Shawn, what it brings to mind for me is the issue of expectations. And I think that we touched on this earlier in this discussion, but that I think as professionals, we have a responsibility to help our clients develop realistic expectations. So I wonder about, folks who consult with professionals who are less scrupulous, who are willing to encourage unrealistic expectations about what might happen in a court process.
I mean, I've seen it a lot, and I've actually worked with attorneys that acted like this, and they would give you, like Mark mentioned earlier, the retainer talk.
Mm-hmm.
I'm going to get you all of these things. We're going to get his left leg in a bag, and he's going to pay all your attorney's fees. And aren't I great? I'm going to do this for you. And then you get into the case, and then the person's telling you, well, that thing I said about, I looked at the court stuff, and it's going to be more like this. And then you're very dissatisfied with your representation because the person that encouraged you to retain them then starts backtracking on all the retainer talk because, of course, they can't give you all of that stuff. One thing that a good piece of advice for anybody engaging an attorney is you want somebody that's willing to give you the bad news at the beginning. If it's all good news, be suspicious, because it's probably wrong. So find somebody that's willing to give you the bad news along with the good news, tell you where your case is weak. And not just assume that everything's going to be just awesome because you've hired them. And also, if you've hired somebody and everything in their marketing, everything in their messaging and their advertising is all about warfare
or winning,
you're going to be entering into a very vulnerable legal arrangement with this person. Don't think for a minute they're not going to beat you to death too. They're going to, if you guys get into a point where there's a dispute over your bill or something, they're going to turn on you so hard. Because that's what they do. It's kind of like there's that parable about the Native American person that picks up a rattlesnake, and the rattlesnake tells him, please take me down the mountain, and I just need the help to get down the mountain. And then when he gets to the bottom of the mountain, he bites the boy. And the boy's like, well, wait a minute, I helped you here. Why did you bite me? Well, you knew what I was when you picked me up.
Yeah.
And I think, if you know what this person is, that they're a nasty piece of work, you want to think twice about entering into a complicated legal arrangement with this person. Yeah. Plus, also, I've learned that the nasty attorneys don't get better results. The really smart attorneys are the ones that understand that this is a human process and are willing to negotiate with their opposing counsel. They're willing to be human about it. Those people tend to do better at court.
But they don't always have the conversation that settlement will be necessary earlier enough in the case. Usually that message is delivered later, and it's a shock to the client because they expected going into court and it's Al Pacino and justice for all. I'll just tell my story and I'll get everything I want like they told me before.
Yeah.
And the reality is that message should be delivered early on, that any divorce ends up with some form of compromise, either one you are engaged in or one that is enforced upon you.
That's true. That's true.
I wonder if that's a question that would be good for people who are thinking about a divorce process. Is there one question that would be one of the most important things that they could ask professionals that they're consulting with? And would the question be, in your experience, what are the compromises that I'll likely have to make in order to have a healthy and successful outcome?
I think that's a good question to ask your attorney.
I think even asking the question, what did you, Mr. Attorney or Miss Attorney, consider a good and successful outcome?
Mm-hmm. Yeah.
Because that's not always the same thing the
Yeah.
attorney sees that the client would see. And that's a lot of the disappointment we see at the end of these cases.
There's that wonderful movie on Netflix. I think I've mentioned it before on this podcast, Marriage Story, with Adam Driver and Scarlett Johansson. The whole premise of the movie is they start off in this divorce context, and they start with a mediator, and that didn't go well. And so they immediately each went to their attorneys, and it became a war. And there's a scene in the movie where the two high-powered attorneys are speaking for them in court. And you watch these people recede in importance. You watch them absolutely lose control of their own lives. And it's kind of a turning point in the film. And these attorneys are just doing what they've been trained to do.
Yes. Yes.
And the judge is just doing what that person can do. The judge doesn't really care about you as much as they'd like to say they do. You're just two more litigants that they had that day. They've had 40 cases that day, and you're just another one. And there's nothing that special about your case for them. And, you're asking these people who don't know you to decide your lives. And there was a litigated case I had years ago. It was a custody case. And I remember going before the judge, and these people were at each other's throats, and I go before the judge, and the judge stands up there and he points his finger at my client and says, "Do you love your children?" And then my client's like, "Yeah, I love my children." And then he points his finger at the other parent. "Do you love your children?" "Yes, I love my children." "Well, I don't love your children. And you're asking me to make a decision about where they're going to go to elementary school. Can you please go out in the hallway and figure this out?" I thought that was a wise judge, actually.
Yeah.
Because we were able to reach a settlement at that point. When it became very clear, you're asking a stranger in black robes to decide the life and fate of your children. Come on. Do you really want to do that? Or do you want to stay in charge? And staying in charge means you work with your co-parent or you work with the other person on the other side to reach an agreement. And, another myth, I've had so many people say, "Well, you don't understand my husband or my wife. They're so charming and they're going to be able to just take advantage of you and they're going to fool you." And just know, if you get a good trained mediator or a good trained collaborator, there's no fooling going on here. We've seen it all. And we can spot the imposters a mile away. And what we're going to provide you is just a very balanced process where you can have a conversation with this person. And the reason you're hiring a professional dispute resolver is not because you're getting along with this person. You're hiring a professional dispute resolver because we have training to help you bridge gaps.
A
Gentlemen,
lot of food for thought here.
Yeah.
We've done it again.
It was almost depressing. I think I need a therapist, Pete.
No, guys, I appreciate that we're talking about this because I do think that expectation setting is so fundamentally important to what we can do for people who, they don't know what they don't know. And they don't know what they think they know that's false or wrong or likely to, cause them to struggle in a process. So I think for us,
Peter, and the other thing it's occurred to me is that people are going through an alternative dispute resolution process. And we know that it's going to take them a year or 10 months or 14 months on average to get through it. And we may have even told them that at the outset, but they get frustrated because the costs are going up and the lack of progress from their perception because they have a challenging situation or a challenging spouse on the other side gets them to a point where they start to throw their hands up in the air and say, I would have been better off in litigation. Why am I doing this? If I just hired an attorney, this would be over by now. And of course, I see the smiles on your faces as I'm saying this, but the reality is there is no divorce going on. This is not a double-blind drug study where somebody's getting a placebo. There's nothing to compare it to. It's frustrating. It costs money. It takes too long. It hurts. It doesn't go away when you walk out of the mediator's office or walk out of the courtroom and go to bed that night. You take it with you. So I think being realistic that it is a process, it's certainly not an event that is going to have its difficult times, and that the team you establish around you is there to support you and will help you get through this. The better the team you have, the more information you have, and the more information we have, the better decisions you can make.
All right. Well, here we are.
Yeah.
We've done it again.
Mm-hmm.
Look forward to your feedback. Anyone that's listening, we'd be very pleased to hear from you. If you have a topic you'd like us to discuss on this, please tell us. In the meantime, I think we can move on to the next cases we all have pending this afternoon.
So Mark, if they want to talk to you about their finances in a divorce, what should they do?
Go to my website. Pacific Divorce Management is the company, pacdivorce.com, PACDIVORCE.com. Fill out the contact form. We will be in touch in a timely manner.
Okay. And Pete, if they need to talk to you about the emotional challenges that they're going to be facing in their divorce, what should they do? Also,
my website, www.peterroussos.com. That's PETERROUSSOS.com, and the contact me page there.
Okay. And anybody wanting to get a hold of me to talk about dispute resolution or to get legal advice, my website is WeberDisputeResolution.com. That's Weber, like my name, dispute, like we had a fight, and resolution, like we solved it.com. Look forward to hearing from folks and looking forward to talking to you next time. Thanks for listening to another episode of the Three Wise Men of Divorce: Money, Psych, and Law. If you like what you heard, be sure to subscribe, leave us a review, and share with others who may be in a similar place. Until next time, stay safe, healthy, and focused on a positive, bright future. This podcast is for informational purposes only. Every family law case is unique, so no legal, financial, or mental health advice is intended during this podcast. If you need help with your specific situation, feel free to schedule a time to speak with one of us for a personal consultation.